Okay, so I've started recording. Tonight, we will have the next group presentation pertaining to a problem of public international human rights law. And we have the Rwanda Justice League doing its presentation tonight. We could probably begin. So I'm going to give the floor now to the Rwanda Justice League to do its presentation.
Thanks, Manjo, and thanks everybody else that's tuned into our presentation live. My name is Michelle, and I'm presenting tonight on behalf of the Rwandan Justice League. With me tonight are my colleagues Carla and Shelley, who will be answering any questions you may have after the presentation. Unfortunately, our colleague Tawanda can't be with us tonight, but we do happily acknowledge his contribution to date. Allow me to just share my screen, the visual presentation, and we will begin. We'll start by looking at the modern history in Rwanda, whose people form tribes. Relevant to our present discussion are the Hutu and the Tutsi. In '94, these tribes turned on each other. Around 1 million people, unarmed civilians, women and children were slaughtered at a rate 5 times faster than that achieved by the Nazis. If we go further back, we look at how international control in Rwanda has causally linked to the atrocities that eventuated in '94. In 1885, an international instrument titled the General Act of the Berlin Conference put Rwanda under German power. Following World War I, Germany was required to relinquish its colonies under the Treaty of Versailles in 1919. Belgium was then given power to rule over Rwanda until the country was capable of self-governance. During Belgian rule, the population was divided into ethnic groups. Tutsi were appointed to government positions and positions of power. Hutu were left to suffer hardship and destitution. The inequality cultivated hatred between the Tutsi and the Hutu. In '59, a Hutu revolt saw hundreds of Tutsi killed and thousands displaced. Hutu gained government control. Tutsi responded by forming a political and military group, the Rwandan Patriotic Front. In 1990, the RPF launched attacks which exacerbated the civil unrest. In '93, the Arusha Peace Accords were signed in an attempt to resolve the conflict between the Hutu and the Tutsi. The United Nations Assistance Mission for Rwanda was established to help implement the Arusha Peace Accord. The UN was warned by the commander of the United Nations Assistance Mission for Rwanda about the imminent massacres. Men were being trained to kill at alarming rates, and a plan was being devised on how to force Belgian peacekeepers to withdraw. That brings us to the genocide. The Rwandan president was killed when his plane was shot down. The following day, the prime minister was also assassinated in his home. The civilian slaughter started just 30 minutes after the president's death. Tutsi and even moderate Hutu were stopped at roadblocks. Women and children were violently raped. Anyone so identified faced death at the hands of their countrymen. Radio transmissions were used to entice hatred and encourage civilian participation in the killing. Tutsi were labelled cockroaches, and the term inyenzi was used to refer to Tutsi as people to be killed. International provocation came when the 10 Belgian peacekeepers protecting the Prime Minister were also killed and dismembered. Following this, Belgium withdrew its forces from Rwanda. USA closed its embassy. The United Nations recommended all foreign nationals be evacuated, and the United Nations Assistance Mission for Rwanda reduced its numbers from 2,000 down to 270. In a world where treaties and customs seek to overcome humanitarian injustices, one has to ask, where was the international community when the killings were happening in Rwanda at this scale? Despite the warnings received by the UN on the impending slaughter, they failed at timely intervention. The issue is that there is a precarious legal basis for both intervention and non-intervention. The conflict in Rwanda was between its own ethnic groups, the Hutu and the Tutsi. This indeed was an internal conflict that warranted, at first blush, non-intervention. However, atrocities committed against civilians in Rwanda included torture, rape, murder. They were gross violations of human rights that threatened international peace and stability. Let's now consider the legal principles that apply to non-intervention. The first principle is state sovereignty. The world is comprised of many sovereign states at liberty to make and live by laws as each see fit. Rwanda is no exception. There is no legislature mandated to create international law. Individual states must become accustomed in their dealings with one another or consent to treaties that serve their respective goals. The effect of written agreements and established custom between states is the same. It is law. Enshrined in the Charter of the United Nations is the concept of state sovereignty, which includes the principle of non-intervention. Sovereign states have a right to self-determination without interference from other nations, including in circumstances that are unfavorable to its citizens. After all, it was held in Nicaragua and United States 1984 International Court of Justice Report 421 that non-intervention is to be treated as a sanctified, absolute rule of law. At the relevant time, it was recognized that armed conflict could either be international or non-international. Conversely, this was later expanded to include conflict between government authorities and organized armed groups in the Prosecutor and Duško Tadić International Criminal Tribunal for Former Yugoslavia, Trial Chamber 2, the Netherlands, case number IT 941T of 7 May 1997. Unfortunately, that decision came too late to offer interpretational value that might have resulted in early intervention for the Rwandans. Getting back, non-intervention at the relevant time was supported by Article 3 of the Protocol Additional to the Geneva Convention of 12 August 1949, relating to the protection of victims of non-international armed conflicts, Protocol 2, which entered into force on the 7th of December 78, which provide that it is not to be invoked for the purpose of affecting the sovereignty of a state to, for instance, re-establish law and order, or as a justification to intervene in internal affairs. The situation in Rwanda was non-international. However, certain internal armed conflict may be capable of being deemed an international matter. The prime legal principle in favor of intervention on these facts of genocide is derived from peremptory norms. The United Nations defined genocide as the deliberate and systematic extermination of an ethnic, racial, religious, or national group. This is derived from the Genocide Convention, that is, the Convention of the Prevention and Punishment of the Crime of Genocide, a treaty entered into force on the 12th of January 1951, which sets out acts that, if carried out with such intention, could amount to genocide. The Genocide Convention specifically allows for parties to request intervention by the United Nations to help prevent or suppress acts of genocide. This, in fact, was requested by Rwanda. We say that on the basis of these international laws, the determination that genocide occurred in Rwanda was a catalyst for international intervention, notwithstanding it occurred on a non-international setting. This is pursuant to the Genocide Convention, which makes genocide a crime under international law and commits all members to prevent and punish. "26 days may not sound like very much if you're counting down to a big celebration or your jurisprudence exam, but here, 26 days is a lifetime, or tens of thousands, in fact. It took the UN Security Council 26 days after the death of the first person to authorize an investigation. They were apparently uncomfortable using the term genocide. 51 days after that investigation was authorized, that is 51 more days of murder at scale, the Security Council authorized France to intervene through a humanitarian mission. On the 4th of July 1994, the Rwandan military gained control and ended the killings. It was 89 days that wiped out 1/7 of the population. To drive that home for you, imagine dead every man, woman and child who currently lives in Cairns, Townsville, the Sunshine Coast and the Gold Coast. In the aftermath of the genocide, the International Criminal Tribunal for Rwanda was established by the United Nations Security Council Resolution 955 in 1994. The aim of the tribunal was to prosecute those responsible for the act of genocide and other serious international humanitarian law in Rwanda and neighbouring states during the calendar year of 94. The tribunal attracted much criticism, including for the length of its trials, the high running costs, its external location, and the small number of cases that it actually prosecuted. A particular cause of outrage was the failure of the International Criminal Tribunal for Rwanda to prosecute the current president, Paul Kagame. Kagame is alleged to have committed war crimes in Congo as the leader of the Rwandan Patriotic Front at that time. International legal observers and Rwandans alike complain that this is evidence of the tribunal only delivering victors' justice. Despite these allegations, the ICTR, along with the ICTY, are said to have legitimized the prosecution of international crimes from these tribunals. There is now a substantial and tangible body of jurisprudence, which was lacking in the past. The ICTR was succeeded in developing important precedents in international criminal law. One such precedent was the first prosecution of rape as genocide against a former mayor in the prosecutor versus Jean-Paul Akayesu, ICTR case number 964T of 2nd September 98. Secondly, a former prime minister was the first head of government convicted of the crime of genocide in the prosecutor in Kambanda, ICTR case 9723S of 4 September 98. Thirdly, the 2003 media cases in the tribunal found a newspaper editor and 2 radio station founders guilty of public incitement to commit genocide and actual genocide. One final but vital legacy I'd like to touch on is known as the International Coalition of the Responsibility to Protect, established by the ICTR. The concepts espoused in that instrument are principles on how the international community ought to respond to future human rights violations. That brings us to the end of our presentation. I will end the visual presentation now, and I'll ask that Carla and Shelley will now answer any questions you may have. Thank you.
Thank you, Michelle. So let me just begin by providing some feedback before we entertain questions from the class. Michelle, you did an excellent job in giving the presentation. Let me begin by talking about the content. The content of the presentation was quite comprehensive. In fact, as I listened to your presentation, as I went through the website that you created, as well as the Word document that you submitted, I didn't realize the harrowing experience in Rwanda, the amount of killings involved, and the fact that genocide actually took place. And so I'm quite happy with the fact that this has been brought to our attention again, that even in recent times, genocide does occur. We would have thought that genocide ended after World War II, and yet it seems to be happening still. And so I'm glad that you chose this specific topic. And so therefore, in terms of the content, as I said, it's very comprehensive. The organization was, the organization of the ideas went also really well, which enabled the listeners to get a good grasp of the factual problem, as well as the relevant international law principles that would apply. And as I said, in terms of the presentation, Michelle did a very fine job because the pacing and the rhythm of her presentation was quite natural. It allowed listeners to really absorb what was being said. And Michelle communicates really well. So on those three criteria, the group did an excellent job. Now we go next to the responses to questions that will be asked. Now, before I start asking my questions, would there be anyone else in the class who may want to provide feedback or ask any question? Okay, there seems to be none. So let me also just clarify, there isn't any other group tonight who would like to do a presentation, is there? So it's just mainly the Rwanda Justice League that will be doing tonight's presentation. Okay then. So no questions, I could begin. So let me focus first on the idea of intervention, because in Michelle's presentation, she cited 3 grounds when intervention by the international community is likely to be permissible. She cited peremptory norms, human rights violations, as well as the threats to international peace. 2 related questions in relation to this specific topic. One, what kind of intervention seems to be permissible? Are we speaking of armed intervention? Are we speaking of humanitarian intervention? And even in relation to the notion of humanitarian intervention, does it permit a foreign state, without the consent of the state in which they're intervening, does that allow a foreign state to intervene by entering the territory of a state such as Rwanda, even without its consent? Second, so that's the part one. The second question simply is, what is this about peremptory norms which seem to authorize intervention by a foreign state? Or even in relation to human rights violations, what is it in international law that seems to permit intervention, whether armed or humanitarian, according to Michelle? Can you just clarify? So 2 questions for now.
Maybe I can help clarify a few things. Hello, my name is Carla. We have seen on the international arena a lot of cases where there is humanitarian conflict or humanitarian law violation, and there seems, such as in Syria now, and in Iraq also, where the international community have not only interfered through peaceful negotiation, such as in the case of Israel and the Palestinians, but also they have demonstrated an intervention through military action. We see that nowadays in Syria, in the Syrian conflict, where the Americans are very active in the war against ISIL by, in the air, by using airplanes, and also the Russian military is reported to sending weapons and arming the Syrian government in their conflict against the ISIS. So there is, yes, they can intervene without consent. In both of these cases, when, especially in the Arab, we see that mostly in the Middle East, most of the countries where there was intervention, military intervention, there was no consent by the government. There was intervention under the umbrella of maintaining international peace and violations to human law, humanitarian law. As for what is it in the peremptory norms, it's just to maintain. I believe there's a convention about humanitarian law that existed before. We have it on our website. I don't have the right name for it, but it's there was a convention before the Geneva Convention that settled in it. They spoke about humanitarian law and the recognition of the mere rights of humans and how humans should maintain peace, or how especially what it was discussed and the agreements that were reached were concerning how the victims, the civilian victims for war crimes, the civilians, that there should be protection of the civilian community during war conflicts, and these rights were agreed upon by the international community. But the convention and the agreement was not acted upon in Rwanda for various reasons, not only because of the state sovereignty, but also because of the political agenda that existed at that time. For example,
Carla, before we go to that, so before we get back to Rwanda, I'd like to pursue the question I raised about intervention. So, well, you've touched upon Syria. You also touched upon what apparently is a conflict between Israel and the issue about the Palestine territories. But what is it in international law that actually authorizes a foreign state to intervene, especially by armed means, in the affairs of another foreign country? That's my question. Is there anything in international law that would permit, apart from the UN Security Council, okay? Is there anything, because you cited, for example, the involvement of the US in Syria, which raises the question, isn't the United States perhaps breaching international law by getting involved in Syria? So assuming that there has been no consent on the part of a sovereign state, is there anything in international law which would permit armed intervention by a foreign state in the domestic affairs of another country, assuming that there is a crime of genocide that's going on? What is that in international law?
Yes, and at first, I think you're referring to the Belgium and Congo case, where there was court held that when it comes to crimes for humanitarian crimes, war, torture, rape, genocide, that there is grounds for foreign states to interfere, using any means necessary to put a stop to any violations of humanitarian law. So there, at first, the international community in the Lotus case was against intervention, and they maintained state sovereignty. But later on, during the Congo and Belgium and Congo case, where Belgium raised, there was one of the judges spoke about, in dissent, actually, he spoke about the reasons and the need, and I believe he said that the need for international intervention, and he cited in his judgment all the peremptory norms, which are rape, torture, violence, genocide, and all these things.
Okay, thank you for that. Let me just make a clarification on the state of the international law here. I am not aware of any ICJ case, or case for that matter, that actually permits a foreign state to intervene in the domestic affairs of a sovereign country on the basis of an allegation that crimes of genocide are being committed without the consent of that sovereign state. There is no law on that, because the basic principle, the basic customary international law is the principle, is the international law on territorial sovereignty. Now, the only instance when a foreign state may intervene in the domestic affairs of a sovereign state without its consent is when there has been the use of armed force against that foreign state. So as an act of self-defense, it can intervene, it can interfere as a way of defending itself, but not for the purpose of trying to stop a humanitarian crisis or the commission of crimes of genocide. So as it is, the state of international law in relation to customary international law is that intervention by a foreign state in the domestic affairs of a sovereign state is not permitted without the consent of that sovereign state. Now, in the case of the United States, I think it's either that the US does it on its own, because as far as the United States is concerned, might is right. So in other words, if you are strong militarily, you don't really care about what the international community says. And especially if the United States is unwilling to submit itself to the jurisdiction of the International Court of Justice. But that does not negate the fact that the United States might in fact be in breach of customary international law by getting involved in Syria. However, as far as the Syrian conflict is concerned, the United States is doing this because it is trying to protect itself because of the involvement of ISIS and ISIL. So the United States is raising the position that it is intervening in Syria using armed force as an act of self-defense because of ISIS and ISIL, which is harming the interests of the United States. Okay, so that should be clarified, because if we give into the idea that if there are systematic human rights violations going on in a specific country, or that crimes of genocide are being perpetrated in a country, if we submit to the idea that it is permissible for any foreign state to just intervene on the ground of the commission of war crimes, where does the principle of territorial sovereignty come in? So it is not allowed. There are only 3 instances, therefore, is it 2 or 3, where foreign intervention would be permissible. One is that is with the consent. So there are 3. One is with the consent of the sovereign state. So in which case Rwanda might request the international community to intervene. In the case of Syria, the Syrian president has asked Russia to intervene. So Russia's involvement in Syria is because of is with the permission of Russia. Arguably, the involvement of the United States is with the permission of the rebel forces, which may be in control of parts of the Syrian territory. And that goes back to a factual question of who has the authority to make decisions in relation to that. But the United States can make an argument that it has in fact been invited, meaning there is consent on the part of a governing authority in Syria, and that is the rebel groups. Okay, so the first way by which intervention by a foreign state can be made is with the consent. Second, even if there is no consent on the part of a sovereign state, if a foreign state has its interests harmed because of the use of force by the sovereign state, it can act in self-defense by using armed force as well against that other state. And thirdly, obviously, we have the case of the United Nations Security Council, which has the power to authorize armed intervention. Are we clear on that?
Yeah.
Now, I have a further question. In the case of the issue about Rwanda, we will recall that the United Nations Security Council authorized the creation of the International Court of Rwanda. And we will realize, therefore, that that international court, in a sense, retroactively applied laws pertaining to genocide to the participants. So in other words, the crime of genocide had been committed. The International Criminal Tribunal was created on the basis of a UN resolution. But the effect really is that the International Criminal Tribunal for Rwanda then had jurisdiction over acts or alleged crimes that were committed prior to the establishment of the military tribunal, of the criminal tribunal, which raises the issue of the retroactivity of its laws. So there is an ex post facto legislation in a sense, retroactivity. I ask that question because if you examine the Rome Statute, particularly Article 24 of the Rome Statute, which is the treaty that creates the International Criminal Court, it clearly provides under Article 24 that no person shall be criminally responsible under the statute for conduct prior to the entry into force of the statute. So it is a principle of the Rome Statute that criminal laws, international criminal laws, should not be retrospectively applied So can you explain to me what appears to be a conflict there? On the one hand, the Rome Statute does not allow retroactivity of international criminal law. And yet, as far as the UN Security Council was concerned, the International Criminal Court of Rwanda seemed to have been given the power to retroactively apply international criminal law pertaining to the crime of genocide.
Please just excuse my internet. If it's breaking up, I'll turn my video off. The Rome Statute was established in 2002, and the International Criminal Tribunal for Rwanda was established in 1994. So the precedent that was, and the article that was referenced in the Rome Statute was created after the International Criminal Tribunal for Rwanda.
So essentially the legal question there is this. Would it be, is there a breach of international law if at some point the United Nations Security Council, for example, may authorize interventions such as in Syria, and in doing so, say that any war crime or any crime of genocide that may be committed by Bashar al-Assad, the president of Syria, will be the subject of jurisdiction of, let's say, the International Criminal Court of Syria. So in that sense, the United Nations Security Council would then allow the retrospective application of international criminal law against genocide. Because in that case, the International Criminal Court would have been created after the crimes of genocide would have been committed. So in international criminal law, what is really the state, what is the principle in relation to the retrospective application of international criminal law?
So when the tribunal was established, there wasn't an alternative other than for Rwanda to deal with it within their own courts. And their courts and their judicial system was in such disarray after the genocide that they didn't really have the capacity, and that's why they requested that the tribunal be established. And I don't think a tribunal can run properly if a tribunal for a specific purpose, such as prosecuting people for a crime that was committed, it cannot function properly unless it can have a retrospective aspect to it. Now that the Rome Statute has established the International Criminal Court and the existence as well of the Court of Justice, it may alleviate the need for this kind of tribunal in the future. However, at the time of the Rwandan tribunal, I think that was the reason that it was justified in being retrospective.
Okay, but I mean, the question, yes.
Can I add to it? Sorry.
Yes.
Sorry. Can I add a bit to what my colleague Shelley said? I believe that international law is all based on mutual agreements between states. It's not a comprehensive body of law such as the domestic law. So it sometimes it follows domestic law and the theories and principles behind domestic law, but sometimes it doesn't. It all depends on what, I think, when the United Nations Security Council gets together and they decide something, it is all based on the consent and agreement between the states, and they I believe that they use the law as they see fit to the circumstances that they have at hand.
So are you saying that it has, the creation of an international criminal court has to be with the consent of a state?
That's not what I'm saying. I'm saying that when the creation of an international, what I'm saying is that when they create an international court, states can agree on the terms of the creation of that court and how and its function, how it functions.
But my question is it permissible for the United Nations Security Council to create an international criminal court to prosecute war crimes or crimes of genocide, for example, without the consent of a specific state that is the subject of the jurisdiction of the International Criminal Court.
Sorry, could you repeat? Because there's a
Yep.
the internet is
So you had mentioned that essentially international law is created by mutual agreement between states. And
Yes.
you also mentioned that essentially the International Criminal Court in Rwanda was created with the consent and upon the request of Rwanda. My question is it within the power, for example, of the United Nations Security Council to create an international criminal tribunal having jurisdiction over a foreign state of a specific state that has not consented nor requested the creation of an international criminal tribunal?
I don't think so, because that would be also interfering in state sovereignty. And unless it has the states that that are part of the United Nations, unless they have interests to protect that they were damaged by what happened in that state, then I don't believe that.
The answer actually yes. For as long as the United Nations Security Council agrees to create an international criminal court, it has the power to do that, even without the consent or even without the request of a specific state. For as long as no one vetoes. I mean, you know, the United States, Russia, or China don't veto. But if the United Nations Security Council can get its act together, and if they come up with a resolution, they would have the power to create an international criminal tribunal, even without the consent of a sovereign state. So that is the exception. That is the other exception.
Okay.
Okay. Now, I could ask further questions, or we
Please
could
do.
end. What?
Please do. I don't mind. This is
Okay, very good. Because we don't have anything else to do. The other option would have been for me to come up with my tutorial questions, but this is an interesting topic. Okay. The sense I had was that there is, of course, the customary law concerning state sovereignty. And state sovereignty, as mentioned, I think by Michelle, is absolute, if I remember that correctly. Now, the question I have is this really correct, that state sovereignty is absolute? So that for another state, for example, to intervene in the affairs of of another state through armed means would be a derogation of state sovereignty, in the same manner that for the United Nations Security Council to authorize the creation of international military tribunal, or worse, to even authorize armed intervention into another state, would in fact be a derogation of the territorial sovereignty of a state. So is there a conflict there somewhere?
If there's no consent and there's no treaty, then it would be against state sovereignty. But if a country is big enough and large enough and has enough arms, then I think they have the power to do it wrongly, perhaps, or rightly. They do have the power to interrupt state sovereignty.
Mm. Okay. Comments? Yeah, so generally we accept that state sovereignty is absolute, but there are recognized exceptions in international law where that sovereignty will give way. In the first place, state sovereignty can be limited through convention, meaning by agreement. So as it often happens, there is, for example, an agreement between two states where one state permits another state to enter its territory, either to set up, for example, a military base. So in that sense, it's permissible for a state to give up part of its territorial sovereignty. The other aspect, of course, is that there is a recognition that while there might be state sovereignty, it cannot be used, state sovereignty cannot be used as a mechanism to just commit acts against another state as well. So, because in that case, that will probably trigger retaliation in the form of an armed self-defense by the other state. But in general, that would be correct. There is the principle, there is customary international law recognizing state sovereignty. Okay. So having said that, I think I'm happy enough to start asking questions. And I'm very happy with the presentation of the group, including its answer to the questions that I've asked. Would there be any other comments or questions from the class? None? Are you happy to end tonight's session? Okay then. So well done to the Rwanda Justice League. I'll be sending the marks tomorrow morning. You did really well, and you came very much prepared. And I'm very happy with the way that you cited international law cases. Really good. So Carla, Shelley, Michelle, that was really good of you. So this was a very good presentation. Well done. So having said that, good night everyone, and I'll see you soon. We won't be having a class next week because it is Australia Day. Thank you. See you soon.
Thank you.
Good night. Bye.
Bye.